And now, without further delay, let's begin today's event. Once again, Coronavirus Workplace Management. At this time, I'd like to turn the floor over to your first speaker, Gary Bossert. Gary, the floor is yours.
Thank you, Adam. I appreciate that. And good morning, and thank you all for attending today's webinar. I am Gary Bossert, Vice President of Operations for Curie Benefits Solutions. We are committed to giving you and your practice the same high level of support through the COVID-19 pandemic that we always have, so that you can focus on keeping your patients safe and healthy. Before beginning today's presentation, on behalf of Curie Benefits Solutions and our attorney panelists from Nelson Mullins, we want to thank you for the vital work you and your employees are doing for your patients, as important now as it's ever been. As leaders in your practice right now, you must run your practice, but in a new, uncharted world. While you are still in the business of treating patients and caring for your community, most of how you did that a month ago is irrelevant. The way you now need to work is more than just adapting the work processes you had in place last week. Your employees aren't just going through COVID-19 as employees. They're going through as full people. We must change how we lead and how we work to adapt to this new reality. To start, we need to respond, not react. Responding means calming the world around us by finding the right information and providing guidance and reassurance to your management team and your employees. To help you with that response, we present today's webinar, Coronavirus Workplace Management. We are fortunate to have a team of attorneys from the law firm Nelson Mullins with us today, including Ann Murray, Rob Sheridan, and Mitch Boyarsky. Ann is a partner in Nelson Mullins' Atlanta office, where she practices in the areas of employee benefits and executive compensation. She is a member of our firm's healthcare team, which focuses on providing comprehensive services to hospitals, physician practices, and other healthcare providers, and assists her clients with all types of HR and benefits-related matters, including those relating to qualified retirement plans and health benefits. Rob is a partner in their Boston office, and his practice encompasses a variety of litigation matters, with an emphasis on litigation and counseling on federal and state labor and employment issues. In the area of employment law, Mr. Sheridan has counseled his clients on a wide variety of employment issues, such as discrimination and harassment, wage and hour law compliance, independent contractor and employee classification, reasonable accommodation for disabled employees, employee discipline, and terminations. He has handled employment and business litigation before federal and state courts and administrative agencies, including state fair employment and human rights agencies. And finally, Mitch is a partner in the New York office and focuses his practice on labor and employment. He advises clients in a variety of workplace subjects, particularly focused on restrictive covenant, wage and hour, executive contracts matters, transactional employment matters, especially related to mergers and acquisitions, and related employment litigation. For more than 25 years, he has represented management in workplace law. Thank you all for presenting today. Mitch and Rob, I'll turn it over to you first. Thank you.
Thank you, Gary. We appreciate the opportunity to speak to the group today. As Gary had mentioned, our firm, Nelson Mullins, is an Am Law 70 firm, and we have about 800 lawyers in 25 different offices throughout the United States. Ann Murray, Rob Sheridan, and I are part of our Nelson Mullins Task Force, which is a multidisciplinary group of lawyers who are regularly working with clients on a variety of these subjects related to the virus. And including our team and our firm deals with technology, securities, banking, government relations, real estate, privacy, restructuring, commercial contracts, and education issues, as well as workplace that we're going to talk about today. But this really involves a multidisciplinary approach that our firm has taken, and there's a variety of issues that come up. We're going to focus on workplace matters for now, but keep in mind that there may be others that are related to our subject matter for which we are regularly dealing with clients as well. So I'm going to jump ahead into the slides now. First, we're going to talk about on the agenda workplace policies and remote work arrangements. In many states, work remote is pretty much the norm. Again, a very, very different age than we were a month ago, as Gary had mentioned. And so the dynamic of workplace has changed. We'll talk about that. Second, Rob is going to talk about the emergency paid sick leave and the emergency FMLA, which is the first part of the coronavirus stimulus plan. And we'll talk afterwards about the CARES Act, which is the loan program and the forgiveness components of that. And then Rob is going to talk about leaves and layoffs. That has become the flavor of the day. Starting several weeks ago, we have advised clients significantly on those issues, including reductions in pay. And now, given the CARES Act and the Payroll Protection Program, it's requiring employers to reconsider those layoff considerations and what they're going to do. Not jumping ahead too much, but there is a deadline by June 30th, 2020 for employers to figure out what they're going to do if they did layoffs and furloughs previously or they're contemplating them, as well as what to consider for reductions in pay. All of that needs to be part of your plan going forward if you have already done or will consider those. And then Ann will touch on the group medical coverage mandates and other related issues. Next slide. I want to cover this almost as a checklist for you of best practices and prevention because some of this, while may be obvious, is a good refresher. There's a lot that employers need to keep in mind these days. There's a multiple situations that come up on a regular basis that is part of this plan, but in addition, we want to highlight some of these high-level points. We understand that employers may be of all different sizes and infrastructures to deal with these. So if you're already doing these items on the checklist, great job, keep up the good work. If not, consider these as your best practices. One of the more effective ways for employers who are open and even those who are dealing with telecommuting arrangements to disrupt the spread of the virus is to help employees to understand basic sanitary obligations, such as washing their hands, staying away from the sick, obviously unless they need to care for someone who is sick. In the workplace, to the extent open, sanitizing services, and doing social distancing. Again, a few weeks ago, no one used those words, social distancing, but now it's become somewhat the flavor of the day. And as time goes on, we understand from the government that social distancing may be a new definition, and there may be additional distance between individuals that the government is recommending. So all of those should be the focus of workplace safety measures at this point. You should recommend that your employees review the CDC website and the WHO website. There are multiple government agency postings and information available at the federal and the state level. If your businesses are remaining open, for extra precaution, you should be providing additional cleaning supplies where available, extra janitorial services. I know that especially in healthcare, employers are doing more for interim and intermittent shifts, closing operations temporarily to do cleaning, and providing other safety measures. So consider those as best practices. At this point, there is very little business travel taking place. Travel is only permitted in states where there is mandatory quarantine orders. In very, very limited circumstances, maybe exemptions for healthcare providers and for emergency responders. Otherwise, travel should be limited. If an employee asks not to travel, including to travel to the office for regular commutation, then we need to consider whether that employee is covered by the emergency FMLA or the paid sick under the expanded FMLA. But generally, as a best practice, I would caution against demanding that an employee travel for work unless the employer is designated as an essential business. Again, this question about whether your business is designated as essential, which may be an easy answer for the healthcare industry, is done on a state-by-state or locality basis. Different states and different localities have issued executive orders. We have posted about that on our website. Just as a housekeeping note, we included on the first page of this PowerPoint the reference or resources page on our website to a lot of this information. I would suggest that you review it. A bunch of these are exactly dealt with on the website page, like executive orders and essential business designations. So you need to know, is your business permitted to stay open in light of these executive orders? In cases where businesses are exempted, it's important to obtain a designation or provide employees communications. It's a written document that you would give to your employee that says, my employee is permitted to travel. I am a designated essential business, and this way the employee can commute to work. Real briefly about telecommuting. Telecommuting, as I said, is something that I'll deal with in a subsequent slide, but is sort of a new workplace arrangement of the day. Beforehand, we provided or recommended clients provide telecommuting arrangements on a limited basis. Now I think employers need to be much more careful in telecommuting arrangements, especially for things like privacy concerns, cybersecurity, and just regular productivity. I will get to that shortly. Task forces. Our firm has an internal task force for our management company, for our management team. It's also important for your company to consider a task force as a way to streamline the decision-making process while getting collective input. It's important not to make knee-jerk reactions and responses to a lot of issues that come fast and furious, but rather to have a sounding board as a resource. I also think as professionals and healthcare professionals, being able to say to your patients and to others that you provide to that you have a task force, because that can give you an extra level of credit and credibility with those that you're doing services with and for your patients. Next slide, please. In terms of quarantine, right, there's obviously a very significant risk for exposure, and so where possible, an employer should consider quarantine measures. Again, healthcare is a very, very different animal, and so quarantine for on-site services may not necessarily be an option. A lot of clients that we have talked to in the healthcare industry have done alternatives like telemedicine. I understand just by talking to one of my colleagues who represents a telemedicine company that their revenue is up by a few thousand% in the last few weeks compared to the prior quarter, given the amount of that business. But obviously, that depends on each business. Perhaps telemedicine is not possible. Where possible, however, and especially in light of quarantine orders, you should consider complying and requiring that employees work remotely. The overarching policies regarding discrimination in the workplace continue to pervade this issue, and especially when we talk about decision-making and disparate treatment, perhaps, regarding race and national origin. As an example, it could be considered discriminatory if you were to direct someone who is Chinese or Italian to quarantine simply based upon that individual's national origin. Or I'm from New York, and if you were to tell someone, not that this is a protected classification, but if in this day and age you're directing people not to interact with and in fact to exclude in the workplace individuals who are from a specific country or because of their national origin, that could trigger concerns regarding discrimination. We can't forget about protections for protected classifications. Also, the issue does come up much more these days about medical testing. The ADA still does apply, although in this day and age, various government agencies have relaxed the standards for discrimination issues, and particularly about the ADA and medical testing. A lot of questions have come up more recently about whether I can take an employee's temperature, and for the most part, the answer is yes. However, disclosing an individual's medical condition would be prohibited, just as it has been up until this time. As an example, if an employee had a predisposition to a heart condition or the individual has diabetes, that would be a prohibited disclosure to the others in the workplace. But if an employee does test positive and that individual was at work during the last 14 days, during the incubation period for the virus, you do have, in fact, not just a right, but now suggested obligation to inform those other employees in the workplace that a coworker did test positive. We have communications that we have prepared for clients about this, but you could inform them that the individual is self-treating at home, if that happens to be accurate, and that they are, okay. But again, you would consider the circumstances under which you're going to disclose that. Informing employees that a coworker tested positive is appropriate. Other obligations regarding occupational health and safety. Overall, the OSHA standards to maintain a safe workplace continue. In healthcare and other regulated industries, that may be even more. So where employees have experienced conditions or reveal to you that they're symptomatic of conditions related to the virus, you need to take extra precautions. Again, additional safety precautions like masks for healthcare providers, wiping down surfaces more frequently, segregating or distancing at work is extremely important at this point, and other related safety concerns that you may be otherwise obligated to file or follow under OSHA is particularly important. OSHA has issued guidance about this, and on our website there are additional resources about OSHA, but there is an OSHA publication specifically that is a very good practical checklist to consider, and that is www.osha.gov/publications/OSHA 3990.pdf. So consider looking at that. Questions come up about workers' compensation, right? There are possibilities where an employee, especially in the healthcare business, contracted the virus during work. Workers' compensation would cover those situations. Again, there may be questions about whether an employee did contract the virus while working or unrelated to work, and that would be more of a determination by a workers' comp carrier. You should make those determinations when in doubt. I would provide an employee paperwork to apply for workers' compensation and tell them that they're free to apply. Eligibility determinations will be made by the carrier. As far as remote work arrangements, again, to the extent that they are feasible for exempt and non-exempt employees, I strongly recommend that you use those. Where not possible, you do have essentially, as an essential business, an opportunity to avoid a remote work arrangement, and that goes back to the essential business designation. More importantly, you should know your policies. You should know what your practices and procedures are for those remote work arrangements. We are, in fact, helping companies with policies as we speak, amendments to their handbook that address remote work arrangements, that address emergency and paid FMLA. It's important, again, for these work arrangements that we protect the company's health information. PHI is extremely, extremely important to protect if an employee is doing telemedicine or other remote work, and that you make sure that we're providing secure technology, that the ability to do the work is not incapacitated by load, and that the systems support the remote work arrangements. Last, for the wage hour considerations, right? When a non-exempt employee is working remotely, they still need to keep track of their time. If they're working more than 40 hours in a work week, they are eligible for overtime. It obviously becomes much more challenging to monitor an employee's time while they are working remotely. And so consider timekeeping mechanisms in addition to what an employee might otherwise use. If an employee is working and is non-exempt, the employer is going to be obligated to pay. So it's even more so important to avoid off-the-clock work. That is basically where an employee is working without your authorization beyond the normal work hours. You're going to be on the hook for it. A little bit different when an employee is exempt. So just keep in mind for the non-exempts, the wage hour implications. Thank you.
Thank you, Mitch. We are now going to talk about the Families First Corona Response Act, which I am going to call the FFCRA because Families First Corona Response Act is a mouthful. You probably have heard about this, but it went into effect yesterday and will continue in effect until December 31st, 2020. There are two components, the Emergency or Expanded Family Medical Leave Act, the EFMLA, and then the Emergency Paid Sick Leave Act, the PSLA. We will start by talking about the Emergency FMLA Expansion Act. First, covered employers. So first, it's going to apply to private employers with less than 50 employees, as well as employees of government agencies of all sizes. In terms of covered employees, the only requirement is that the employees have been employed by the organization for 30 days. There are some exemptions that are important to note. The first, of course, and relevant to this audience is healthcare providers and also first responders. In addition, certain employers under 50 employees are exempt if it would affect the employer's ability to continue as a going concern. Now, what does that mean? Well, the Department of Labor, the DOL, issued a rule yesterday, so this is hot off the press, and it stipulates that small employers would not have to grant this leave if doing so would raise expenses above revenue, such that the employer would cease operating at a minimal capacity. The absence would pose a substantial risk to employers' financial health or operation because of the particular worker's skills, knowledge, or duties, or the employer cannot find enough workers to perform the work of the employee requesting an absence. What would be a covered event? Well, a covered event, and there is only one under the EFMLA, it would be where a worker cannot work or telework because they are caring for a child who is out of school or daycare because the school or daycare facility has been closed due to a public health emergency related to COVID-19. This is the only covered event under the EFMLA, and if you read about the bill before it became law, this actually changed. What are the benefits under the EFMLA? Well, the first 2 weeks of the leave may be unpaid, so the first 10 days, but the employee can substitute other paid leave that they have available. And we'll talk about that a little bit more when we talk about the Paid Sick Leave Act. After the 10 days, the employees are paid 2/3 of their salary, and it's up to $200 a day or $10,000 total for the entire period. If you have a part-time employee, the pay rate is going to be based on the hours normally scheduled to work in a 2-week period. If this is unknown or it's variable, an employer can average the hours worked over the last 6 months. And lastly, if the individual has not been employed for 6 months, the company can utilize the hours agreed to at the time of hire or average the rate over the entire term of employment. One question that comes up frequently is, can employees use this leave intermittently, like employees can with the regular FMLA? Yes, provided the employer agrees. The DOL has issued some FAQs that are pretty helpful on this, and they are encouraging flexibility with this leave to help everyone deal with this crisis. Next slide, please. Great. What sort of notice does the employee have to give? Well, one, they should provide notice as soon as practicable. And one question that we've been dealing with a lot is, what does this notice consist of, or what should it consist of? The IRS has weighed in on this yesterday as well. The employee note requesting leave should include the employee's name, the date or dates for which the leave is requested, the statement of the COVID-19 related reason that the employee is requesting leave, and a written support for such reason, and we'll get into that because there's only one COVID-19 related reason applicable to the EFMLA, and then a statement that the employee is unable to work, including by means of telework. When we're talking about the school or daycare closure here, the statement from the employee should include the name and age of the child or children to be cared for, the name of the school that has closed or place of care that is unavailable, and then lastly, and this is interesting, a representation that no other person will be providing care for the child during the period for which the employee is receiving family medical leave, and with respect to the employee's inability to work or telework because of a need to provide care for a child older than 14 during daylight hours, a statement that special circumstances exist requiring the employee to provide care. This leave under the EFMLA is job protected until the earlier of the end of the leave or when the public health emergency ends. There is an exception to this job protection, and that's where an employer has under 25 employees and an employee is on leave due to a public health emergency, or the employee's position no longer exists because due to the economic circumstances or other changes in operating conditions of the employer that affect employment. Next slide, please. Okay, this is the second component of the FFCRA, and this is the Emergency Paid Sick Leave Act. Covered employers here, very similar, in fact the same. It applies to private employers with less than 500 employees, as well as employees of government agencies of all sizes. There's a difference here with respect to employee eligibility. The PSLA applies to all employees regardless of the employee's service time. Exemptions here, the PSLA also exempts healthcare providers and first responders. And then, of course, what about that small business exception, those employers that have under 50 employees that we discuss with respect to the EFMLA? Well, based on the DOL rule that was issued yesterday, our interpretation is the small business exception would not be available for the PSLA unless the reason that paid sick leave is taken is for COVID-19 related school or daycare closure. In other words, that would be the only reason to deny a employee leave under the PSLA, even if your organization is under 50 employees. All right, next slide, please. All right, so what are the covered events under the PSLA? Well, the first one is the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. The employee has been advised by a healthcare provider to quarantine due to COVID-19 concerns. An employee has been experiencing COVID-19 symptoms and is seeking a medical diagnosis. An employee is caring for an individual, not limited to a family member, subject to a federal, state, or local quarantine or isolation order, who has been advised by a healthcare provider to self-quarantine due to COVID-19 concerns. An employee is caring for a child if the child's school or daycare is closed or the child's care provider is unavailable due to public health emergency. Or lastly, an employee is experiencing any substantially similar condition as specified by the Secretary of Health and Human Services in consultation with the Secretary of Treasury and the Secretary of Labor. And what benefits are available under the PSLA? Well, eligible employees are entitled to up to 80 hours of paid sick leave, so about 10 days. Part-time employees are entitled to be paid for the number of hours that they work during an average 2-week period. Sick leave for covered events 1 to 3, if you look at the previous slide, that would be COVID-related self-care, is paid at the employee's regular rate up to a maximum of $511 a day or $5,110 total. For sick leave taken for covered events 4 through 6, which in the previous slide would be care for others and sick leave due to other government-specified conditions, this leave is paid at 2/3 the employee's rate with a maximum paid leave of $200 a day or $2,000 total. Employers should note here that this emergency sick leave is going to be in addition to any company-provided or statutory sick leave. When we talk about statutory sick leave, oftentimes we're talking about states that have sick leave mandates. Employees have the option to take emergency sick leave before any other sick leave is available to them, and this emergency sick leave is not going to carry over from year to year. A big question that we get is whether employees can use paid sick leave under the PSLA to gap fill for that first 10 days of EFMLA leave. And the answer is yes, and the Department of Labor has also issued guidance on this. PSLA notice. All right, so we've already discussed what sort of notice an employee should provide for a COVID-19 related school or daycare closure. How about those other grounds listed under the PSLA, those other covered events? Well, this is very similar. You know, the employee should note their name, the date or dates for which the leave is requested, a statement of the COVID-19 related reason the employee is requesting leave and written support for such reason, and a statement that the employee is unable to work, including by means of telework, for such reason. The statement from the employee should include the name of the governmental entity ordering quarantine or the name of the healthcare professional advising self-quarantine. And if the person is subject to quarantine or advised to self-quarantine is not an employee, the person's name and the relation to the employee. It's important to note here with respect to both types of leave under the FFCRA, so the EFMLA and the PSLA, that employers have an obligation to post a conspicuous notice related to employee rights. The DOL has a model notice on their website. Given that everyone is pretty much teleworking these days, we would recommend that an email be distributed with this notice. The post should have been made by yesterday, so if you haven't done so, we encourage you to do so as soon as possible. There is a prohibition against discrimination and retaliation for employees taking leave under the FFCRA. Given the wide scope of employees who are affected here nationwide, we think that the FFCRA is going to be a ripe area for potential litigation down the road. So it's important to get this right now.
Thanks, Rob. Now let's move to the CARES Act, which is the most recent legislation that has been signed into law. So many of you have heard that loans are available through the CARES Act. The three main loan or SBA relief programs that are in the Act are the Paycheck Protection Program, the Emergency Economic Injury Disaster Loans, EIDLs is what everyone's calling them, and the relief for certain existing small business loans that you may have already taken. There's also what they call Title IV, which is assistance for mid-sized businesses that focuses on businesses with 500 to 10,000 employees. We're going to first talk about the Paycheck Protection Program because this is certainly the one that has gotten everyone's attention, and I encourage anyone who thinks that they may be eligible to immediately start contacting the bankers with whom you work and investigating, starting to collect your information so that you are ready to submit your application. So the Paycheck Protection Program has set aside $349 billion to help companies that have 500 or fewer employees. Now, when you count your employees, I know for almost everyone on this call, that's not going to be a problem. However, just note, if you have any types of related employers or related entities to you, for example, if you are let's say a surgery center that might have some affiliations with a hospital system or doctors groups, you need to talk with your advisors and your counsel to make sure that they're not treated as affiliates with you, because the SBA rules for who are affiliates is completely different than what you may have dealt with your 401k or health plans or other measurements, or FMLA even. The SBA affiliation rules are very broad, and so they will consider just even control over another entity, not necessarily ownership, to, in some cases, trigger affiliation. So you can inadvertently or unknowingly find yourself over that 500 number without even realizing it. So the loan that's available is equal to approximately 10 weeks of payroll. Basically, it's your average monthly payroll times 2.5. But in no event can you exceed $10 million. And there's going to be loan forgiveness available. So let's focus on, who's eligible, how much can you borrow, what kind of forgiveness. These are certainly the hot button items that we all want to know the answers to. So first, the way that they're going to work these loans is actually, I'm sorry, somehow that jumped forward. Let's go ahead and go back to, there we go, who's eligible. So basically, you're going to find that all businesses are eligible if they meet the requirements for the size. Now, nonprofits are also eligible for this relief. What's important if you're a nonprofit is at this point it's only available to 501c3 organizations. So if If you are a different type of nonprofit under a different 501c, you need to stay tuned. There's some discussion about whether or not that's going to be perhaps broadened to cover other eligible employers, but at this point, it's not. Governmental entities are also eligible, although they're not eligible for some of the later forgiveness. How much can you borrow? So the way that this works is you actually base the amount that you could borrow on your payroll costs. So in order to determine your payroll costs, you take into account your salary or wages capped at $100,000. So note, there's other payments are eligible to be included in payroll costs, but it's just the salary and wages that you're going to be capping at $100,000. You're then going to basically add in a list of different other payroll expenses, commissions and similar compensation. We don't know if similar compensation includes bonuses, but that's certainly something that a lot of experts are tending to recommend gets included. Cash tips, pay for vacation, parental, family, medical, or sick leave, severance pay, payments, employer premium payments or employer cost for group health plan benefits. So that would be your medical, your dental, your vision, possibly HSA contributions you might be making or HRA contributions, and payment of any retirement benefit, which may mean that the amounts that you're contributing as a employer match or employer profit sharing contribution, those may be able to be counted as well. And then payment of any state or local tax that's assessed on employee compensation. So you take all those costs over the 12 months prior to when this loan originates, and you figure out what your average monthly cost is, so divide by 12, and then multiply by 2.5. If the end result is less than $10 million, then that's what you're entitled to apply for. If it's more than $10 million, then $10 million is what you can apply for. So there is an expedited process that they've set up. The reason that they've done these as SBA loans is because the SBA banks are already equipped to handle these applications. And so any SBA bank initially will be able to handle these applications, and banks who were not previously SBA qualified, there's a process where they're going to be able to also get into the mix. How much loan forgiveness is available? So this is the key here. You're going to get this loan and kind of picture it like it's a bucket. So let's say your loan is $2 million. You have this $2 million bucket. And from the time your loan originates, you have 8 weeks in which to kind of fill up your bucket with permissible expenses that will, for any of those expenses that you're able to kind of fill up your bucket with, your loan is going to be forgiven. The principal of your loan can be completely forgiven if you can fill that bucket up with permissible expenses. So what can you use for your permissible expenses in that 8-week period? Well, you need to use 75% of it has to go to payroll costs, and same payroll costs I just talked about a few minutes ago, whether it's retirement, salary up to $100,000, severance, all those different things. Interest payments on your covered mortgage obligations, covered rent obligations, and covered utility payments. These are all defined in the law. So, as far as utility payments, talk with your advisors and consult the statute for more detail on sort of what qualifies and what doesn't qualify. You're able to use so that's what determines your forgiveness. If you can fill your whole bucket up during that 8-week period following loan origination, you can have your loan completely forgiven. However, there are some areas where your loan forgiveness can be decreased. And those areas are if you have decreased the number of employees, actually the average number of full-time equivalent employees per month, if during the average during this 8-week period is lower than the average that you had during the period beginning with February 15th of 2019 or ending June 30th of 2019 and continuing for the full 1 year look back. If your employee count has decreased, then your loan forgiveness will also be decreased kind of on a pro rata basis. I'm not going to get into the complicated calculation here, but just know that if you've let employees go, whether on furlough or terminated, also if you have decreased any employee's pay who earns $100,000 or less, then that can also decrease the amount of forgiveness that you get. Note, when we talk about decreasing an employee whose pay is $100,000 or less, it's kind of this weird calculation where they look back at 2019, and if the employee earned on a pro rata basis more than $100,000 in any pay period, that employee is excluded from this 25% limit. But otherwise, you're applying this 25% limit. You know, if you decrease their pay by 24%, that doesn't trigger this. But 26%, now your forgiveness is going to get decreased. What's really important is to note is that even though you may have let some folks go or you may have decreased someone's pay, if you've done that between February 15th of 2020 and April 26th of 2020, and if you bring that person back by June 30th of 2020, or you return their pay back up to the original level by June 30th of 2020, they don't count against you. So you sort of have this ability. I mean, you still have the ability to make adjustments for the next 3 or almost 4 weeks, but really 3 weeks. And then you have time to go ahead and kind of get your everything in order and ramp people back up. So long as you do that by June 30th, you won't have a ding on the amount of loan forgiveness that you're getting. So these are quite rich loans. The interest was supposed to not exceed 4%, and the announcements that came out put it at 0.5% interest. So even if it's not, even to the extent that something is not forgiven, and is merely deferred, that's a spectacular interest rate. There's no administration fees, no personal guarantees required, no prepayment penalties. You don't have to demonstrate that you're unable to obtain credit elsewhere. As I said earlier, you can apply through any SBA lender. So I encourage you to reach out to whatever banker you work with to find out if they can assist you. And if not, the SBA website does have a list of SBA-approved lenders. And I believe that we also have a link on our resources page to some of the SBA information. The second category of money that's out there and available to folks is the emergency economic injury disaster loans. So these are loans that are basically, they set aside $10 billion for these EIDLs. They're 30-year loans. This is truly a loan. You're not getting amounts forgiven here. But they're available to small business concerns with not more than 500 employees. For some reason, the first rule for the Paycheck Protection was 500 or fewer, but here we have less than 500. There are some things that need to be cleaned up in some of these rules. But these are available if you can show that you have actually been negatively, you've suffered substantial economic injury as a result of COVID-19. What's interesting about the emergency economic injury disaster loans is you go through this application process, and the applications do open tomorrow, April 3rd, for these loans. But there's also the ability to get an immediate $10,000 advance under these loans. When you get that advance, it will be delivered to you within 3 days. And even if your EIDL loan is never approved, whether it's approved or not, the amount of that advance gets forgiven. So it's really more of a grant than an advance, if you think about it. So something to consider, many people are stacking these where you can apply for an EIDL loan now, or like I said, starting tomorrow, and then you can go in and later apply for your Paycheck Protection Program loan. The EIDL will then be refinanced and included within the Paycheck Protection Program amount. So there is a way that those work together. Note that, so like I said, so the loan advances will be counted for the PPP loan forgiveness purposes. And then there's the SBA relief for existing loans. If you have an existing SBA loan, you can apply to get relief so that the SBA will pay the principal, interest, and fees for 6 months, beginning with the next payment date. Once again, if you already have an SBA loan, reach out to your lender to find out what the process is to get this deferment and to make sure that you're taking full advantage. Now, I mentioned the Title IV loans. I believe that most people on this call will not be impacted, but just so you know, the Title IV loans cover a huge swath of the industry. This covers airlines as well as, the financial system and the banks. But there is specifically assistance for mid-sized businesses. So those of you who have 500 to 10,000 employees, these Title IV loans will be available. At this point, we don't have any guidance on how they're going to run these. We're expecting that we should receive more guidance over the next week or so, but right now they're so focused on the Paycheck Protection Act and EIDL loans that we haven't seen anything come out with the Title IV. Stay tuned. One of the nice things if they do come out with the Title IV loans is they're projecting that the interest rates will be less than 2%. There will be no principal or interest due for at least 6 months. There won't be any loan forgiveness, but there's going to be a whole process where, similar to back in the Great Recession a decade ago, there will be some executive compensation limits, and there will be some certifications that have to be made. What's really important is for any of you who might potentially be dealing with unions, there are some specific prohibitions on fighting any type of union organizing activity. And so discuss that with your labor and employment counsel before you go down the road of one of these Title IV loans, if that's a concern. Okay, there were several employer pay provisions in the CARES Act. So regardless of whether or not you're going for a loan, you just need to know that these are also out there. But also you need to realize that if you apply for certain loans or plan to apply for certain loans, several of these tax credits and delays won't be available to you. So the first of those is you are now able, beginning with any payment due after March 27th of 2020, you can delay paying Social Security. That's the employer portion, 6.2%. And if you delay it, you will not, so it's not a forgiveness, it's delayed. You'll owe half of it by December 31st of 2021 and half of it by December 31st of 2022. So great opportunity to save some cash at this point. But it's important to note, this is not available to you if you are going to apply for a Paycheck Protection loan and have that forgiven. So really important that you make your choices on what type of relief you're going to try and seek. Also, there's a retention payroll tax credit for employers. So if your operations were fully or partially suspended due to a COVID-19 shutdown, or if you can show COVID-19 shutdown order from the government, or if your gross receipts declined by more than 50% when compared to the same quarter in 2019, you can take a payroll tax credit equal to either 100% or 50% of qualified wages. Now, qualified wages, what's tricky about this is we're talking about wages that are paid that you pay to employees who are not providing services. So in other words, people who were put on a paid leave or paid furlough, you're able to get those costs. Or if they were on an unpaid leave and you paid for their health care while they were on that leave, those may qualify as qualified wages as well. The credit's capped at $10,000, but what's important here is the credit is taken on a calendar quarter basis, but it's taken against the other Social Security taxes you may owe. And it is a refundable credit. So if, for example, you're able to defer your Social Security taxes or you are able to take a credit for more than the Social Security taxes you owe, there's actually a method where you can apply for a refund and the federal government will get that to you very quickly. This does not apply if you receive a Paycheck Protection loan, regardless of whether you seek forgiveness on the Paycheck Protection loan. If you apply, you are not eligible for this retention payroll tax credit. There's also some provisions that are going into effect. These are mostly optional with employers, but if you have a 401k or other tax-qualified plan, you need to be aware that the CARES Act broadens your ability to offer in-service withdrawals and planned loans to your participants so that you can, up to $100,000 in certain qualifying cases. They also allow the taxes to be spread out on in-service withdrawals, and there's actually a way where employees can pay those back over a longer period of time to not have them count as withdrawals. So gives people access to money, at a time when they may need it. So it's really a nice thing for you to be able to offer to your participants. If you have a cash balance or defined benefit plan, especially if you kind of have that combination where you cross-test, note that your employer contributions for 2020 to that defined benefit plan can be delayed. And so, and that actually, I'm sorry, there's a typo there. It says delayed to January 1 of 2020, but that's actually delayed to 2021. So that's, take advantage of it if it's something that you need there, because that can be costly. Also note that if you have anyone that takes required minimum distributions from your plan, which is historically was people that had hit age 70 and a half or older, it's been increased to age 72. But if you have folks that are in that group, there is an ability for them to delay taking those required minimum distributions so that they're not negatively impacted by kind of what's happened in the stock market. And then group health plans have to cover with no copays the cost of, and no cost sharing, so no coinsurance, no 80/20. Got to cover the full cost of testing for COVID-19, as well as the office visit costs that were incurred in order to obtain that testing. Now, if someone goes to an office visit for another reason, and you need to be careful as a healthcare provider in how you're coding these things. If they come in for another reason, that other reason they came in, that portion of the office visit is not automatically covered by health plans. It's just the portion that relates to getting the diagnostic testing. When a vaccine is eventually available, there will also be a requirement to provide free coverage with no cost sharing. So important to note, hopefully sooner rather than later. There's also some little lightening up on HIPAA protections, and HIPAA is still certainly out there and protecting, but with everything going on, there's a little bit of relaxing. There was always a question on whether you could pay with no copays or no cost sharing for telehealth services prior to someone meeting the deductible in their high deductible health plan. They have clarified that you can allow it, so a plan can pay first dollar for telehealth services prior to meeting the deductible. And then now FSA and HSA accounts can be used to purchase over-the-counter medications, much like you used to be able to do prior to 2011, and also can pay for menstrual care products. For some reason, that got into the CARES Act. There's, for those of you that may be offering tuition assistance or educational assistance, they have increased the amount of student loan subsidies that you can provide to $5,250. That includes any other educational assistance you might offer. if that's something you're interested in, be sure to check with your advisors to make sure that you're properly implementing it. Now we're going to turn it over to Rob to talk about, briefly, leaves and layoffs.
Great. Thank you, Ann. I'm sure many of you, like a lot of our clients, are facing the tough choices as to how to deal with the economic fallout from the COVID-19 crisis. One option is a reduction in hours. The thing to think about here is that there are wage and hour implications for reducing employees' hours, and there's a difference between what happens with exempts and non-exempts. For exempt or salaried employees, remember that if they work at any time during a work week, they're generally entitled to their full salary. For non-exempt or hourly employees, they're only entitled to pay for the hours worked. So if they're doing no work and otherwise not entitled to paid leave, then the baseline is they're not entitled to pay. A reduction of hours also has a variety of implications that a company has got to stay attuned to, including the potential that employees could lose exemption status by falling under applicable salary thresholds. With respect to benefits, all else being equal, employers also have to be focused on the fact that employees could lose benefits eligibility if hours are reduced below the threshold required by the applicable plans. We have found, however, that insurance companies have been very accommodating in these times and fashioning solutions to help companies deal with this crisis. Involuntary furloughs. What is a furlough? So a furlough is a mandatory suspension from work, generally without pay. It can be as brief or as long as an employer wants, and many companies are implementing or they're considering furloughs in lieu of or in tandem with layoffs. What's the difference between a furlough and a layoff? Well, a furloughed employee generally has an expectation that they're going to return to work. And also, again, generally speaking, a furloughed employee will retain their benefits. Compensation during furloughs. One key thing to think about is that no work can be done by the employee during the furlough. This likely is going to mean cutting off email and media access, because once an employee does work during a furlough, a payment obligation is triggered. And this also has sort of profound implications for exempts versus non-exempts, because if you have an exempt who answers an email during a furloughed week, they are entitled to their full salary for that work week. Furloughs can and should be structured to maximize unemployment benefits to employees. Access to facilities, this is less of a concern nowadays since most people are remotely working, but access to facilities that are still open should be restricted to furloughed employees, but the call is ultimately going to be made based on the business needs of the company. We've already covered technology considerations, so let's talk about layoffs and plant closings. In a layoff situation, you have to be aware of the fact that you may trigger WARN obligations. The WARN Act is a federal law that provides employees with 100 or more employees, and it requires 60 days notice of termination to affected employees in the event of a mass layoff. It's important to note that WARN has aggregation rules. So if you are planning a series of layoffs in quick succession, it's best to speak with your counsel now regarding compliance. In addition, many states have so-called mini WARNs, and they may have lower thresholds and different notice provisions. So again, companies need to take a holistic approach to their plans concerning layoffs, furloughs, and reductions in work, reductions in the hours. Unemployment. Many states are changing or have already changed their rules regarding unemployment eligibility, including but not limited to eliminating waiting periods. While the benefits determination is ultimately up to specific states' departments of unemployment, if employees are laid off, they are generally entitled to benefits. Going back to Ann's discussion of the CARES Act, it's really important to think about reductions in hours, layoffs, and furloughs in tandem with some of these new stimulus packages that have come out, including the CARES Act, because if you are laying employees off or you're reducing their hours, this may have implications for loan forgiveness under the CARES Act, and further, you may have an ability to make up for those lost employees by hiring them back or bringing their hours back up by June 30th, 2020.
Thank you, Rob. Now let's just move to the final topic, and we'll be through this very quickly, but benefit mandates and options. So one of the important things to remember is, right now it's a scary time. I mean, you all know this because, your healthcare providers, people are very concerned what's going to happen if they do, get the COVID-19 or one of their family members, is diagnosed with it. It's important to take a step back and just consider what's available currently in your health plan. Are you fully insured or self-insured? And what can you offer to help people? Whether or not your people, I doubt that you have too many people who are teleworking because most actually have to be in your offices and dealing with patients. But you may want to consider making sure that telemedicine is available because they probably have family members at home. Nurse helplines, what are you doing on laboratory testing? Is there in-home delivery possible for those who might get diagnosed with or have a family member that's diagnosed? And what's in your employee assistance program, if you have one, that's available for counseling or outreach for high-risk groups or for those who just mentally are having issues with dealing with all of the scares. These are all things to take a step back, talk with your broker, reach out to your insurer, or if you're self-insured, see what you can change or upgrade in your plan to make sure that everyone's taken care of. You may want to, as I said, you have to waive copays or other co-insurance for the testing and eventually for the vaccines and the related office visit. But it's important if you are self-insured to remember it's up to you to amend the plan to actually provide for that. Just because the law says it's mandatory doesn't mean your plan automatically falls into compliance. So make sure you've taken those steps. If you're fully insured, that's going to be taken care of. But also if you're self-insured, make sure that if you do amend, you need to make sure that it gets forwarded to your stop-loss provider so that that additional cost will be covered by the stop-loss provider. Rob was talking about leave and furlough related issues. Your benefits are really an important place to focus as you make these hard decisions about whether to reduce people's hours, whether to put them on leave, unpaid leave, or whether to terminate them. Because each one of those is going to have a different impact under your health plan and, frankly, your other benefits as well. Most health insurance and even self-insured will provide some period of coverage for company-approved leave. That is where, for a lot of the furlough situations, you can look at your policy or your plan document and see whether or not, maybe you get up to 30 days or up to 60 days. If your plan doesn't allow that, maybe it says, hey, the minute you go on leave, you don't get anything, reach out to your insurer or other, third-party administrator to see whether or not they are willing to waive that limit. Also, consider if someone's going to go on unpaid leave or if you're reducing their hours to below, let's say, 50%, how are they going to continue to pay their premiums? You can offer to pay premiums on their behalf, but also consider how you're going to recoup those costs. And then on the investment side, in your 401k plan, you are likely the plan administrator and you may be on the investment committee or make the decisions for investments. This is a good time, given the stock market, to make sure that you are putting together a special meeting. And when you have a special meeting, make sure that you're reaching out to your investment managers or advisors and finding out from them, are there any steps we should be taking? Document what they tell you so that you are protected, so you can show you thought about this and whether any changes were needed to your plan. I noted earlier that 401k loans, some of the provisions have changed due to the CARES Act, and they're allowing a larger amount of loans out there. But also consider, depending on whether you do furloughs or terminations, making changes to how your repayments are made to 401k loans. Most plans will trigger a loan default when someone terminates employment. So if you are going to lay off and plan to rehire within 30, 60, 90 days, you may want to see if you can amend your plan to not automatically default the loans and perhaps to try and delay, usually till the last day of the quarter following the quarter in which someone terminates. That's sort of your maximum. But that's something to consider. Similarly, suspending repayments if someone goes on an unpaid leave. They're not going to have money. How are they going to pay back their loan? There are provisions that allow you to suspend payments if someone is on unpaid leave. What gets tricky, and work with your advisors, is if you simply reduce someone's pay, for example, put someone on 50%, there is not a clear ability to suspend payments. So that may impact your decision because, that can be a big issue for some employees who may have sizable loans out there. I already mentioned that the hardship and emergency withdrawal limits have been increased. You can delay the required minimum distributions, and you can delay the pension funding. Other areas to minimize your costs right now, a lot of people are looking to kind of squeeze anything that they can out of their budget. If you haven't made your 2019 contributions, check to see, are they discretionary? Are you really locked in? What representations have you made? Because you may be able to put that off. And what we're really focused on here, we already talked about pension contributions you're able to put off. We're talking here about your 401k and profit-sharing contributions, whether it's a match or a profit-sharing contribution. Your 2020 contributions. If you have a safe harbor plan, you may have already issued a notice that told people what they were going to get under your plan. But most safe harbor notices and even the safe harbor rules will allow you in certain circumstances to still cancel that safe harbor status mid-year. So if you want to do that, talk with your 401k providers and make sure that you get some good guidance on that. Also, if you make contributions on, let's say, a match on a per pay period basis, check your document to see, is that really required or have you just proactively been doing that? You may be able to push those matches to year end. And keep tuned for more special exemptions. It's literally daily, if not hourly, that we're getting guidance from the government right now. So just stay tuned for additional exemptions and additional special rules that will apply. Okay, that's a lot of information for everyone. We thank you for contacting us. To the extent that anyone has follow-up questions, we're always available to answer those, and you'll see a contact here on our Q&A sheet where you can reach out and we will get back to you. Gary, I don't know if you have any questions that have come through.
I do. I have a couple. But first, Dan, I just want to touch on something you said about benefits, particularly as it relates to self-funded plans. Many of the folks participating on the call are covered under the Medical Society plan, and I just want you all to know that we will continue to communicate with you directly as there are benefit changes that correlate to what Ann described or any eligibility changes as we have over the last couple of weeks. So you will continue to receive those emails, and if you have any questions specifically, feel free to email me regarding the Medical Society plan. We do have a number of questions, but I do want to thank Mitch Rob, and Ann for providing such thorough and good information today. We do appreciate that. Also want to note that you should see on your screen now a window where you can download the slides from today's presentation if you'd like. We are now going to take a few questions. We've got some that have been coming in since the beginning, and I'm just going to take them in order of the presentation. For anyone who is not planning to stick around for the Q&A, I just want to thank you again for joining the call. So going back to, I believe this is probably a question for Rob. Rob, there's a question about the 10-day non-paid waiting period for caring for a child due to closure. Well, I guess the first question is there a 10-day non-paid waiting period for those who will be out to care for a child due to closure? And then second, does the poster of employer rights, it doesn't note that, so I guess that's why there's a question, if you could respond to that.
Yep. So the answer is yes, there is a 10-day waiting period under the EFMLA. However, probably the reason that the poster doesn't mention the 10-day waiting period is that you are allowed to sub in the paid sick leave time for that 10-day waiting period. You can also utilize any other sort of paid time off that you might have. So if you've got existing vacation time, you could utilize that to fill in that 10-day gap and do so at full pay.
Very good. Thank you. And Rob, this is another one for you. This goes back to, I believe, the Emergency Paid Sick Leave Act. And the question is whether you could please clarify that 50-employee exemption for the 2-week paid leave.
Yep, certainly. So the 50-employee exemption is going to be only available for paid sick leave. That exemption is only going to be available and be able to be utilized by companies based upon somebody taking the paid sick leave for a school closure. In other words, it is not going to be available just for the paid sick leave for any of the other COVID-19 related concerns. So if I'm stating this correctly, you can deny an employee paid sick leave because if you're under the 50 employee exemption, you can deny paid sick leave based solely on a school or daycare closure.
Great, thank you. And Rob, I think this next one is for you too. So the question is, do furloughed or laid off employees need to be notified for both paid leave? So I guess the people who had been laid off or furloughed prior to these acts, do they now have to be notified about these paid leave opportunities?
So they are not going to be considered employees, so they don't, but you should make sure that your notice goes out to all of your current base of employees, and furloughed employees would not be entitled to utilize any of the benefits under the FFCRA.
Well, but just for clarification, that's an important point that Rob was making earlier. There's your decision between furlough versus layoff. You know, a layoff, they've terminated and they're not employees. Mm-hmm. But if they're merely put on unpaid leave or furloughed, they're still employees. So they would still be getting that notice. It's just that, as Rob was just saying, they're not actually going to be entitled to any pay or to take that leave because they weren't scheduled for any hours. You know, they're on they've already been, docked the hours in a sense.
Yeah.
One other point. Yeah, and just one other thing, if I can add, is that if an employer decides to return an employee from the furlough during, let's just say, the 12-week period that the FMLA would apply, at that point, the employer should notify the employee of the notice or the leave entitlements. Thanks.
The next question, I think, Ann, is for you. This goes to, so if the person who was laid off does not want to come back to work, can you substitute with another person at same pay rate by June 20th to show data for loan forgiveness? So basically replace one person with a different person.
Yeah, that's an interesting question. I mean, I think that my gut is that the answer would be yes, because what we're saying is that your total number of full-time equivalents needs to be back up to its prior levels by June 30th. However, there's not 100% clarity. Mitch and Rob, you haven't seen anything on that, have you, that it makes it employee-specific?
Yeah, and I'll just add, this is Mitch, that while there's nothing specific, what the employer is going to do is look at its payroll costs over the prior period for the aggregate, and then a measurement going forward, right? So it would include any new hires or rehires during that period. So as far as we can interpret it right now until there's further guidance by the Department of Labor on this issue, is that any new hires prior to the June 30th date would be considered part of the aggregate to determine the payroll costs.
And I think what they're getting at is the forgiveness, the reduction of the forgiveness for not having your head count at a high enough level where I was saying if you reduce someone's pay or you let them go between February 15th and April 26th, then as long as you bring them back by June 30th. But I think along the same lines to what you're saying, Mitch, I think that it can be just, I don't want to say people are fungible, but I think that you just have to get the numbers back up. It's not bringing that particular person back, but we don't have guidance on that particular point, so that's something to stay tuned on.
Very good. Ann, I think the next one is for you, too. This is about the tax credit. So the question is, employers with fewer than 100 employees can claim as qualified wages all wages paid to employees, whether they were at work or not working. Any requirement for full-time rate of pay?
Yeah, so this is, if you're talking about the retention payroll tax credit for employers, that qualified wages, what's unusual about this one is this is defined as people who are not providing services. So this is not your people who are still at work and providing services. This is only really going to help you if you put people on paid furlough or paid leave, where they are sitting at home getting pay and not providing services.
Very good. Let's see. The next question has to do with loans. So total amounts have been set for the loan programs. For example, the $350 billion for the Paycheck Protection Program. The question is whether once all those dollars are allocated, will loan applications stop, and how much urgency do you believe there is to begin applying for those programs now?
Yeah, very, very good question. Certainly there's that set amount has been allocated, so there is always the thought, how fast is it going to go? We don't know. We don't know if Congress will step in and just automatically augment that if they're pushing the limit. I think for that reason it's important that, and generally I take the view, if you think that you will qualify and think you may need the money, I would rather be at the front of the line than the back of the line. And, so even if you can't submit an application yet, make sure that you've done all the legwork, so you've basically calculated your payroll costs, you've, started to get all your numbers together so that you can expeditiously get your application completed and in, because, I wouldn't want to be at the end just to find out that they aren't going to renew something.
Very good. The next question is for me. It's specifically about the North Carolina Medical Society plan and whether we have any changes pending. So we've announced a number of changes already, relaxing eligibility provisions for reduction in hours and furloughed employees. We've announced changes, obviously, as Ann had mentioned, no cost sharing for testing and diagnosis of COVID. And yes, I do fully expect there to be more announcements coming as things develop. It's very fluid at this point. One thing that you should be aware of is that we are going to send out an announcement soon relaxing premium payment and extending deadlines for premium payment. We know that practices are struggling on both the revenue side and being able to pay premiums and probably other bills as well. So expect an announcement on that very soon. And anybody who has a specific question about medical side plan benefits can certainly email me directly. The next question, does the Department of Labor have forms created for an employee to request the leave, or do practices need to create their own? Are there templates available for those requests?
Yeah, so I'll take this one. They do not have templates yet, although both the DOL and the IRS has provided guidance as to what sort of content the employees should put into those requests. And to get the tax credits for the FFCRA, employers should retain those documents and also be careful about the retention of documents and segregating documents that contain health information so that they can abide by HIPAA rules.
Very good, thank you. And then finally, here's a question. Would a pay loan include or be forgiven for the balance due on a 2019 401k Safe Harbor employer profit sharing contribution?
Can you repeat that question again?
Sure. Yeah, I think they're asking if it would be retroactive to balances that they would normally be paying now for a 2019 profit sharing contribution.
Well, and that's where I was saying, I think it's important to check your document. If it is a fixed contribution that you committed to, I do not believe that you will be able to avoid or defer making that contribution. However, for a lot of plans, your 2019 contribution may actually, even though you've never thought of it this way, may be something that says it's completely discretionary with the employer. If that's the case, then it would give you the ability to decide that you're not going to make that contribution with respect to the 2019 year. But it really depends on how your plan is written. If for 2019, there is no deferral available. It's all going to come down to a decision of whether or not it's discretionary and whether you just aren't going to make it. It's not like you can just put it, even if it's discretionary, you're not going to be able to put it off and then still take a deduction, by making it, let's say, next year or something. However, given that tax return due dates have been extended for businesses as well, you should consult with your accountants and advisors because you will have additional time to make your 2019 contributions because they're generally due by your tax return due date. So confirm that with your accountants, but that may at least give you a little, a few months of breathing room there, which, let's face it, it's something.
Yes, absolutely. Well, again, I want to thank Ann and Mitch and Rob for providing us such great information and being generous with your time today. I want to thank all of you who have attended. Again, if you haven't downloaded a copy of the presentation, it is still available on your screen. Nelson Mullins has provided an email address if you have follow-up questions. And as always, you can certainly email or call me directly if there are questions about your health insurance benefits, the medical site plan, and so forth. So again, thank you. Thank you for all that you are doing for your patients and our communities. Stay well and be safe. Thank you very much.